Good evening. The hour of 6 p.m. having arrived, I will call to order the special meeting of the Planning Board. This meeting is being broadcast live on the City of Keene YouTube channel. The video is also streamed on the city's website and is posted on the website by the end of the next business day, barring any technical difficulties. All actions taken during this evening's meeting will be posted on the Planning Board webpage on the city website. Copies of the printed agendas are available in the wall pockets as you entered the meeting room. The minute taker is participating remotely this evening. Board members, please be sure to turn on your microphones when speaking. If the minute taker is unable to hear, they will ask you to speak louder or turn on your microphone. I will now call to order this regular meeting of the Planning Board and declare a quorum present. Will staff please conduct the roll?
Harold Farrington, Roberta Mastrogiovanni,
Here.
Councillor Mike Remy,
Here.
Mayor Jay Khan, Sarah Vizani,
Here.
Ryan Clancy, Kenneth Cost,
Here.
Armando Rangel,
Here.
and for the alternates, Stefan Mayu, Brandon Markelon, Tammy Adams, Mike Hafer, and Joseph Cosavera.
So we are here for a motion to rehear PB-2024-20, relative to a major amendment to an issued earth excavation permit for the properties located at 21 and 57 Route 9 in Keene, which has been submitted by James Manley of Sullivan, New Hampshire. Do you have anything that you could help us with in terms of clarity here?
Thank you, Madam Chair. Yes, this is definitely something that the Planning Board is not very familiar with, so I worked with legal counsel to put together a memo for you just outlining the standard of review for this evening. This is not a public hearing. This is just a meeting for you all to decide as a body whether or not there's a reasonable basis for scheduling a rehearing. So the standard of review, both the state statute RSA 155E-9 is the state statute that talks about appeals, and that also references RSA 677-3. And both of those set the standard for the board's review as being simply whether a decision or order by the planning board was unlawful or unreasonable. So in your consideration of the motion for a rehearing, you should review whether the motion has set out facts or law that the planning board has overlooked or misapprehended. And then the planning board should only grant a rehearing if the requester can demonstrate that the planning board committed technical error or that there is new evidence that was not available at the time of the first hearing. And then to assist with this analysis, there's 4 questions listed here. The first is there new evidence that is being offered that was that the requesting party could not have had available to them through reasonable diligence at the last hearing? Is there a legal standard that was misapplied? Was there evidence or facts that were misstated or misunderstood? And were there factual determinations made for which there was no written evidence or testimony provided in support? And then the motion for rehearing is in your packet. And then for the record, I just want to state that there was a response to that motion for rehearing that was submitted by the attorneys for the applicant G2 Holdings. And then a subsequent response to that response was submitted by the petitioner, Mr. Manley, through his attorney. And so that information has been provided to you, but it was provided to you just a couple minutes ago. So there are, I believe, representatives from both of those entities here this evening if you wanted to hear from them. You don't have to, though. Tonight is not a public hearing, so there's no requirement that you open it up for public comment. So that would be at your discretion.
Thank you, appreciate that.
Yep.
Board members, do we want to discuss a little bit about how to proceed here? Yes. Mike.
Thank you. In the initial response letter, it calls into question the standing of the individual requesting the motion for rehearing, of their right to ask for a motion for rehearing, because they're not an abutter to the city of Keene. Do we have any thoughts on that? I mean, if they're not an abutter in the city of Keene, do they have the rights to bring this before us at all?
Yes, ma'am.
Thank you, Madam Chair. So my understanding, and I am not a land use lawyer, but my understanding in reading 155E9, it states that any interested person affected by such decision may appeal to the regulator for a rehearing on such decision or any matter determined thereby, period. So in this instance, the person who submitted the appeal is a direct abutter to the overall property. The property is bifurcated by a town line, so they are not a direct abutter to the portion of the property that's in Keene. I think that's something for this board to decide
Yeah.
or consider.
So the answer is it's not super clear, because to your point, it does read, I brought my book tonight. Yeah, that an interested person isn't super well defined. Yeah, any interested person affected by such decision may appeal. So, okay, I have a hard time saying that they're not interested or affected, as being that close. So,
Anyone else have any input here? Cool. Yes.
Thank you, Madam Chair. Looking at it is a little bit vague, and perhaps that's by design so that an interested party could be just that, interested in the decision and therefore request it. And then in the response to the response after the response, that they say that he is an interested person, and they explain why they think he is. And reading through that on this response, it can't necessarily see a reason to argue it unless I'm missing something.
I kind of want another couple minutes to finish reading, because we do
Well,
have these literally
it is
2
a bit
minutes
to read,
before-
guys, so the other thing we have the option to do is listen to the parties. I don't know if we want to do that anymore at this point, but whether he has the right to the rehearing, I mean, he
Right.
is in a butter, he's not a Keene resident, correct? So
Yeah, I just think at first, like, if we could maybe just like kind of talk it through for a minute
Yeah, I think
together,
we
like,
should.
and give us and then like take a minute to read as we're going
agree.
through it. But like, if we address that first point of the interested party, and we read through the response to the response, maybe we could try to find something that indicates clearly one way or the other.
Does anyone know where Sullivan's side stands on this project yet?
No?
I believe that they have a hearing scheduled for, I want to say October 15th or something like that. But I believe they still need to hold a public hearing and have their decision on the Sullivan end of things.
What impact does the Sullivan decision have on our decision?
The Sullivan decision will impact the portion of the expansion that's proposed to be in the town of Sullivan. It wouldn't impact the portion that's in Keene, because they can get to the entirety of the portion that's within Keene from Keene. The inverse is actually not true, because Sullivan, the portion of their property that's in Sullivan, they can't get to unless they go through the portion of the property that's in Keene.
But if Sullivan were, let's say, not to vote in favor, then, and what is the regional impact at that point? I mean, if any? you know?
I think that would just change the extent to which they can expand their operation.
Right.
They'd have to keep it to the Keene side, the town of
Do
Sullivan.
we know how many acres are on the Sullivan side, by any chance? Yeah, I don't know.
Not in our.
Yes, Ken?
So I'm looking at the response to the response, is that right? From Mr. Manley. And it says that what's popping out to me is that G2 erroneously relies on the standard requirements of RSA 6772 and 6723, rather than another RSA 155E9. So I'm not having time to read that and finding out which one really is the one that matters. So it's very hard to, you know, in this situation to know what the merit is of that particular argument about erroneously relying on something else. I don't know if that's the case or not. And you have the book?
I do have the book.
Madam Chair,
Yeah.
may I have
Yes,
the
ma'am.
RSA book in front of me, so I'm happy to read
Please,
those
yes, if you
sections.
could, please.
But the RSA 155E is the section of state code that deals explicitly or specifically with earth excavation operations. So this is the portion of state statute that regulates and actually gives the planning board the authority locally to regulate an earth excavation operation. And then within the earth excavation regulations, section 155-E9, which is the paragraph that deals with appeals, it references the procedures specified in RSA 677-4 through 15. And so I think the point that's being made here is that it doesn't reference 677-2. I think the complicating factor is that if you go to 677-4 through 15, I believe in there's a reference to 677-2 that's very common in the state statutes. They are often cross-referencing each other. So I think from staff's perspective, the way we're reading this is just going back to the 155E9, where it says that any interested person has standing to appeal.
Without having, you know, legal advice here, you know, which is probably not a bad idea, it appears that he may have the right to appeal according to these statutes. Am I right or wrong?
I mean, that's the way that
I'm not a lawyer.
I read that.
Yeah, it's certainly gray, because it is in the section that's referred to, the 155E9, it sends you to
The 677
677-4.
is,
And 677-4 in that section says basically, it was identified that this person didn't have standing. It was not a person directly affected under 677-2, and refers back to 677-2 as that. So it's a circular reference error, but it does, 155E9 does tie back to 677-2 in that pretty quickly.
And if that's the case, that it's any interested party, then why isn't it automatically granted a hearing when an interested party asks for a hearing? Like, why would there be a vote on that if it's just an interested party? And it's that general.
well, it's pretty clear he's not just interested, he's in a butter, so it's, you know what I mean?
Well, he's not.
The argument is he's not a butter, he's
He's not.
keen.
Right, and then that's gray too. We don't, it just says any interested.
So if that's the case, and I'm not saying it is, I'm just saying if that's the case, there's a couple other ones that they address in here, but if that one is clearly part of it, would that be enough to grant that, or do we feel like they have to? I mean, there's 4 major areas to go through. New evidence, the legal standard misapplied, evidence facts, misunderstood, factual determinations. So is that enough right there? If we determine that we agree on that, is that enough? Or do we feel like we need to go through each one and sort of pick those apart? Sort of just a question for you guys.
I think that the idea is
Yes, Ken.
basically that,
Go
sorry,
on.
go ahead.
Either one.
I was gonna say, I think the idea is basically that if any of these questions were found to be,
Okay,
case, then it would
that's sort
be-
of the way I was thinking, but I wanted to make sure.
Do we want to go, yes, Ken?
Thank you, Madam Chair. So we went through a lot of this with intense engineering studies. You know, it was almost like dueling engineers, and they were count, point, count. And it was very technical and very difficult, but we worked through it, and we came up with a vote on what we thought, based on those engineering studies. So nothing in those engineering studies have changed. They're done, we looked at them, we made a decision on them. So as I look at these things that are listed on, well, summarized on the motion, but they do capture everything pretty well, I don't know that anything has changed since then. So, you know, like the first bullet is talking about dust and noise, and we went through all kinds of studies and engineers, and they looked at it and said the vibration likely isn't affecting anything, and the one that could be a little bit interesting to me to just look at again might be the visual impacts, but going past that, the vehicle trips a day, I think is taken care of, that if they do exceed that, then there's, you know, they'll have to come back, but we're going on the basis that that's the vehicle trips they told us, and we agreed. Visual impacts is in this motion twice. I don't know if something is missing or it's just a duplicate. Vibration, noise, blasting, and then it talks about damage to features significant natural scene of historical importance, and I think I know I had a lot of interest in the visual zones 1, 2, and 3, and I think if this was in a visual zone 1 or 2, and we were drastically changing the nature, that would have meant something else to me, but it was in a visual zone 3, which is sort of really the least important in what we decided as a city. So I think we addressed that. So I'm just struggling that there's anything that is different than before. I got one more thing though, and so on the visual impacts, it will change. I think we'll see cliffs over time. And again, maybe if those cliffs were in visual zone 1 or 2, that would have made it, at least for me, would have made a bit of a different decision, but they're not. So I'm just I'm trying to go through this and seeing what is different that I would change my mind right now.
Yes, Sarah?
Oh, that's a great point. And so the first thing I was looking at was just their first argument back and forth about the interested party piece, but when you really look at the reasons why we would approve a rehearing where new evidence, a legal standard that was misapplied, I mean, and then anyone could just have the interested party. So I agree with you that there's no new, like, I don't see anything in here that suggests new evidence, or facts that were misunderstood. I don't see that so far. So I thought that was a great point, Ken.
Yes, Mike?
No, I think that was really well said going through it, is like, I don't think there's any information that's like, we didn't have that information. We discussed each of these points when we went through it. I mean, to the point of like the trips per day, we literally put a condition in the letter or in the approval around the trips per day. Like, I think a lot of this was discussed and reviewed as a board. We talked about the water table. We talked about the view. We talked extensively about the view, both from the historic importance and from the adverse visual impacts. We talked about the vibration. We heard testimony around it. Yeah. And to your point, we had expert opinions. I'm just echoing what you just said. I don't see anything that's different than what we originally learned, even from the letter, from the responses.
So I would agree that going through all those points, we carefully, did consider all of them. But now, to assist in this analysis, the question is there new evidence that's being offered? I mean, what at this point is being offered? Yes, Armando?
So I think that we did cover a lot of these points in our discussions, but I don't think the application addressed all of them. You know, I don't think that the application really did talk much about, you know, the loss to property values that property owners will experience because of this project. You know, they did address like the, you know, monitoring of vibration, but there's still, you know, a lot of noise that wasn't really addressed, like what will happen because of that. And then, you know, I mean, we did address the traffic to a certain extent, but still, like, there's still some different opinion about that, about whether or not those trips were actually accurate. And then the visual impacts, like, sure, we did talk about them to a certain extent, but the thing is, there are going to be lasting effects from this project. And, you know, a lot of the public, from what we've heard, is not happy about that, you know. So I know that, you know, there's zones, there's 1, 2, and 3, and this could be in a 3, but still, you know, it doesn't, from what we've heard, it's still not satisfying. So I think that there's nothing new presented, but the original application didn't address all of these concerns.
So the concerns of property values decreasing and visual impact are still somewhat of a concern possibly.
Yeah, and noise,
And the
and
noise
dust,
potentially.
you know, and in the land development code, like, those are all reasons to dismiss an application as well.
Mhm. Yes, Mike?
Thank you. So we're not here to vote on whether we agree with the decision we originally made, right? It's about, is there something new that's been brought forward that we missed, that we didn't talk about, that would change it and cause for rehearing, not to say whether we agree with the decision that was made. So at that point, if acknowledging that we did talk about the view, we talked about the view, right? It wasn't like there's new information coming out that it's going to be different than we originally thought. We made a decision based on the same information that's in front of us today. Whether we like it or not is not the question, as far as I understand it. And on the noise, it's the same thing. We heard it. And then on the property values, there was scientific studies submitted by the applicant for the property values piece and a letter from a local real estate agent. So taking those both as expert opinion is how we're supposed to perceive them, or how we're supposed to understand them. They did provide evidence on those, so it's not like it was an undiscussed point. And that's where I have a hard time. Well, you know, I agree that there's a lot of, you know, folks in the public that don't necessarily like the decision that we made. I don't think that there's any new information in what we found to justify reopening it, having it already been decided. That's where I'm stuck.
Yes, Mary?
Thank you, Madam Chair. I just want to add in here that there's sort of two things that you should be looking at. One is there new information or information that you missed? And so I think you're doing a good job of covering that. And then the other item is whether or not there was a, let's see, how did we word it? Misapprehension. Basically, did you make any mistakes? Because this is really an opportunity for you, if you feel like there were any sort of errors made the first time around, to correct them. So you can, as a board, decide to revisit something that you've already talked about if you feel like you made a mistake in applying the law correctly, or you know, making a decision without any evidence to support it, something like that. And then if you were to do that, you do have the ability, it's our understanding, to limit the rehearing to that specific topic.
Well, new evidence has not been provided, correct? There is no new evidence. So does anyone see new evidence that would change our decision? Ms. Bazzani?
No, I thank you, Madam Chair. No, I don't see new evidence. But to Armando's point, the misstated, misunderstood part of it that we are to be looking at for the application, and reading through the initial motion for rehearing, I think we need to decide as a group whether or not we did violate a couple of these, and just agree that we didn't, or we did, or agree that we did. But I think that that's important to address, so that we understand. So if you're looking at the first motion for a rehearing on page 5, I think it starts actually on page 4, but we're talking about, they're really focused on whether or not we are protecting the health, safety, and welfare of the people of Keene, and obviously of Sullivan too, but of the areas around the property, and whether or not we violated this by voting for it. I think that that's an important piece we just acknowledge and maybe agree or come to a decision on whether or not we think we did. That way we're addressing each one for the, I'm not sure how we define Mr. Manley. We'll just call him that. We'll address that for him.
Do we feel comfortable as a board making these, legal decisions? Is some of the questions, yes.
Well, I don't know if I'm comfortable, but I think we have a lot of information here.
Right.
And we're acting on, not necessarily legal, but on, or did we miss something or make a mistake
Right.
or something like that? And so I was wondering if, since you were talking about items, if you can kind of define which ones you want us to discuss, and then we could go through those.
Yeah, I was just, one really just like popped. I just wanted to, I'm not sure that I think we did. I just know that it's in here and it's a concern of his, and I would like to address that concern regardless of how we decide to vote. So it does talk about how we violated our own regulations, and specifically, here, we'll do some. The planning board shall not grant approval for an earth excavation permit in the following instances, and then they address several of them. One of them relates to health, safety, and welfare under Article 25 of the LDC. We can read through that on page 5, paragraph 2. A potential hazard to human health, safety, and welfare, the environment caused by adverse impacts associated with an excavation project. Adverse visual impacts is mentioned in here. Excuse me, is mentioned in here. And then it goes on to talk about those. So I do feel like we did a good job of leaning on the experts, and that we added in a lot of regulations and additional stipulations for this particular application and applicant. But I do want to just sort of agree, like, talk about that, if we did or not. I personally don't feel that way. I don't, based on reading through the notes again, I feel like we addressed them all, but I do think it's important to just talk about it.
Anyone else?
Well, I'm going to maybe talk about that. I mean, when I'm reading that, what it says here in Mr. Manley's request is that he's saying that the applicable standard does not require an actual hazard, rather the mere potential of a hazard requires denial. My mind is spinning on that, because anything I do when I cross the street, that's a potential hazard, whatever you do in life. So how do you not do anything because it's a potential hazard? Now, if there's a legal thing that we have to, any potential hazard, you can't do anything, but don't believe that's the case. So it's just not, to me, holding that much weight, because that's just an impossible standard to address in anything. If someone could, we have time, maybe we could look at that in a little more detail in the RSAs or something, but, so that one, right there, sort of says, yeah, whatever you do, don't do it because it might have a hazard.
Do we have Article 25B of the LDC that, so it quotes it, when the issuance of a permit would present a potential hazard to human, like, do we have that?
25.2B just says when all necessary, so 25.2 is prohibited projects.
Yeah.
The planning board shall not grant approval for an earth excavation permit in the following circumstances. 25.2B is just when all necessary local, state, and federal permits have not been obtained.
And then C and E he references underneath it.
C is when the issuance of a permit would represent a potential hazard to human health, safety, and welfare, or to the environment caused by adverse impacts associated with the excavation project. And it goes on to give examples.
And E is,
When the existing visual barriers in the area specified under NHRSA 155E3 would be removed except to provide access to the excavation, which is one where they're not removing the barrier, they're not removing that front
right.
visual barrier.
It's, yeah, it's,
Yes.
And I recall, and from reading that, there was a lot of discussion about hazards like dust, and there's gonna be dust control, and it's gonna be managed, and it's part of the operation, and that was included in how this is gonna happen. So it was addressed in the application. Vibration and other hazards were addressed by monitoring and checking and doing what has to be done. So I think each of these hazards were presented to us and addressed with some kind of mitigation or some kind of management for them. The idea of the visual impact, yeah, it's gonna change the visual impact, but it's gonna change the visual, it's gonna change the look. But it's doing the things it has to do. It's keeping, what we say is keeping, as you just said, is keeping the, the visual screening and things like that. So again, I just don't see that we didn't think about that, we didn't debate it, we didn't talk about it, and we didn't come to a conclusion. I don't think we made a mistake, and I don't think we made a mistake.
Yeah. I agree. Oh, just a question for staff.
Yes, ma'am.
So,
Yep.
Mary, do we need to have the petitioner speak or anything? I know you mentioned not public hearing, but like, if we were ready to do a motion here to see where it goes, do we need to open it up at all, or no?
It's fully at your discretion, if you want to call up the applicant or the petitioner for the appeal.
If you're open to it, I would make a motion at this point, because I'm curious if there are folks who, if you have something specific that you want us to talk about, I would rather talk about it. I know, Armando, you brought up some examples, but if there's something specific you want to go through, we should talk about it. That's what we're here for. And I'm happy to pause before I make a motion to do that, but other than that, I'd rather see where we are, because we don't have to be 5-0.
A motion in terms of inviting the applicant?
No, I would move to
Just move
make
to-
a motion based on what we have here. I'm personally not inclined to open it as a public hearing
Yeah, no, I mean, we've really gone through this
extensively.
extensively.
yes, and
I
I think they laid out a lot of good information in the motion, the response, yeah, so I don't feel like there's a lot of additional information I need to move forward. I just want to make sure that we address them, but I think we're doing exactly that, so I'm good with that.
So basically, we have gone through the 4 topics that we really need to focus on here as a board. Does anyone have any, doubts on that? Is there new evidence? We haven't seen any. The legal standards, have they all, do you feel that they've all been met? Are there any facts or evidence that were misstated or misunderstood? And was there any factual determinations made where there was no written evidence or testimony provided in support? Those are the big questions. If we don't have objection to those, I guess we have to move our motion. Yes?
Can I ask we do a roll call? Thank you. For a vote, instead of, once we go to a motion. I don't want to end up surprised at the end,
Okay.
that's all. So with that being said, I would be open for making a motion unless I'm right. Okay. Move to deny the motion for rehearing for PB 2024-20 relative to a major amendment to an issued earth excavation permit for the properties located at 21 and 57 Route 9. Upon review of the request for rehearing and arguments raised therein, the board determined there were no points of law or fact that were misunderstood or misapprehended. The board did not commit any technical errors, and there was no new evidence presented that was not available to the moving party at the time the board issued its decision.
I'll second.
All those in favor?
Oh, I asked for a roll.
Oh, roll call, sorry.
Sorry.
All right, Roberta Mastro Giovanni,
Yeah, it's yes or no.
Yes.
Counselor,
I don't know.
Counselor Mike Remy,
Yes.
Kenneth Cost,
Yes is denying the request
Correct.
for the rehearing,
Yes.
right? Yes.
Sarah Bazani,
Yes.
Armando Rangel.
Yes.
Okay, so it's unanimous. There will be no rehearing granted this time.
Anything else for us?
Well, there were those more time items on there that I forgot.
So there are some more time items. One, a potential modification to the site plan review thresholds. And two, training on site development standards for snow storage and landscaping.
Let's leave them on more time for Harold.
All right,
Make him work hard.
all right, we are all set. All right. at
They didn't give you a
6:37.
gavel?
They didn't give me the gavel,
Adjourned.
sorry.
Yeah, okay.